So if you look at the origin and evolution of the POSH Act, it was expected that a lot of women will be entering into the labor force. Around 40% of the women have been subjected to verbal abuse, 45% of the women have been subjected to physical abuse. So Vishaka is not a name of an individual, but Vishaka is a group of NGOs petition the Supreme Court regarding some sort of respite from the sexual harassment of women from the workplace. And this is important from the perspective of fundamental rights. The POSH Act provided for the constitution of what is known as Internal Complaint Committee. Hello everyone, a very warm welcome to all of you. My name is Prateek, and in today's video, we are going to look into the applicability of the POSH Act in the political parties. Recently, Supreme Court dismissed a petition that wanted to include the political parties within the ambit of the POSH Act or the Prevention of Sexual Harassment Act of 2013. This decision has invited a lot of criticism, and in today's video, we are going to discuss what exactly is the basic ingredients and the background of the POSH Act, why it was needed, what has been its achievement, and what exactly was the reason given by the Supreme Court to exclude the political parties from the ambit of the POSH Act. So let us start the discussion. So if you look at the origin and evolution of the POSH Act, so basically POSH Act is a short form of the act called as Sexual Harassment Prevention, Prohibition, and Redressal Act of 2013. And this act was passed by looking into the fact that women in the labor force were subjected to several kind of issues or problems. So if you look at the date or from the time 1991, some major developments were happening. Indian economy was opening up, so it was expected that a lot of women will be entering into the labor force. So this was happening, and it was also the time when the society was moving from joint family to nuclear family. So there was huge round of migration as well. So in a way that also led to the demand of domestic help. Now, there were several problems that women were facing at the workplace. This included disparity in income. For the same work that the women would do, they would get lesser income as compared to men. That was one of the challenges that they faced. The second one was something known as glass ceiling effect, which meant that women were not considered fit for promotion or at the leadership level, and in a way it was considered that there's an invisible glass ceiling that prevented women to occupy the leadership position. Why? Because of patriarchy and because of the fact that women were considered to be full of emotions, and they would not be good at making objective decisions. The third most aspect of discrimination that they faced were sexual harassment at workplace. Now, sexual harassment can be both a civil offense and it can be a criminal offense. With respect to the criminal part, it was already against the law under the earlier IPC provisions, but there was no problem or there was no legal aspect with respect to the civil aspect of sexual harassment. So there was a legal vacuum that was there in the 1990s when the requirement for a sexual harassment law was needed. Now, for this, we had several measures. For example, for disparity in income, there was already laws that prevented the employers from providing different income to men and women for the same work. Also, there was some sort of measures were there for encouraging leadership of women. But there was a vacuum here. Now, significantly, India was a signatory to a convention called CEDAW, that is Convention on Elimination of Discrimination of All Forms Against Women, and India ratified this in 1993. So all of this were going on. There was a demand, there was a need, and there was international convention, and more importantly, we had fundamental rights, Article 14, Article 15, that would provide the forms of equality to everyone, irrespective of gender, caste, etc. So it was incumbent upon the government to ensure that the right to equality is also advanced at the level of employment as well. In fact, there was also Article 21 that provided for right to live in a dignified environment. Okay. Now, within all these things, one important development that happened was in 1992, when a social worker whose name was Bhanwari Devi, she was gang raped in Rajasthan. Now, Bhanwari Devi was an employee of the Rajasthan government, and she was campaigning against the evil of child marriage. But the elites of the society did not like that, and she was ostracized from the society, and ultimately she was gang raped in front of her husband. And that led to a huge national outcry. And a couple of NGOs grouped together and sought some sort of guidelines from the Supreme Court to ensure that there is no discrimination or harassment in the workforce. And these set of NGOs that combined together to petition the Supreme Court, they were called as Vishaka. So Vishaka is not a name of an individual, but Vishaka is a group of NGOs that clubbed together to petition the Supreme Court regarding some sort of respite from the sexual harassment of women from the workplace. And Supreme Court understood this, that yes, Vishaka, that sexual harassment is a menace that prevents women from enjoying their freedom at the workplace. In this was very important because of three reasons. First, Supreme Court provided a very comprehensive definition of sexual harassment. The second important reason why Vishaka guidelines were important was that it provided for, or it filled the legislative vacuum. So there was no law that was there to prevent sexual harassment of women at the workplace during this time. So Supreme Court used its power under Article 141. So if you look at the provision of Article 141, it says that any ruling given by Supreme Court will have a force of law throughout the territory in the country. So Supreme Court, using its power under Article 141, gave the guidelines that was considered to be part of law in the country, and that was supposed to fill the legal vacuum that was inherent when it comes to the sexual harassment prevention in the country. The third important reason, or the element of the Vishaka guideline, was that it sought to give expression to the international convention. And this is important from the perspective of fundamental rights, because Supreme Court said that if we have accepted or ratified any international convention and they are in line with our fundamental rights, then we can consider them to be part of our legal rights, even though they have not been specifically mentioned in the Constitution or in the law particularly. So these were the important reasons, or some of the important highlights of the Vishaka guidelines. Now you may be wondering that the Vishaka guidelines were given in 1997, but why did the sexual harassment or the POSH Act came only in 2013? What happened during this time? So during this time, even when the Vishaka guidelines were given, there was a lot of dispute with respect to who should be considered as part of employer, right? Should the private sector be also considered? Should the NGOs be also considered? Then there was a lot of dispute with respect to domestic help. Should the domestic help should also be considered? And there were a lot of challenges, lot of dispute, right? Then things were also heating up with respect to several crimes against women. So there was a demand by the activists and especially the National Commission of Women to make it as stringent as possible, right? Then there was Justice Verma committee that was formed in the aftermath of the Nirbhaya incident. So Nirbhaya incident happened in 2012 in December, and because of that reason, there was a consensus among the political parties that now we have to provide some sort of act in some sort of way, right? And this led to the enactment of the POSH Act, or the Prevention of the Sexual Harassment Act of 2013. Now, this was very much in line with the Vishaka Guideline, and it sought two things mostly. It provided for the explanation of the terms like sexual harassment. It also provided what should be the domain or the areas of the workplace that should be considered here. It also talked about which kind of employees will be under the domain of the POSH Act. So once this was clarified, then it provided for certain mechanism as well. So within the mechanism, the POSH Act provided for the constitution of what is known as Internal Complaint Committee. So what was Internal Complaint Committee? So any organization, whether it is public or it is private, if it has more than 10 members, it is bound to constitute a committee that is called as Internal Complaint Committee, where the aggrieved employee would lodge her complaint. And then the ICC will look into the nature of the complaint, it will investigate, and it will then suggest remedial measures to the employer. And the employer is expected to take action along or in line of the recommendation given by the ICC. And those organization which has less than 10 employees, they can use what is called as the DCC, or District Complaints Committee, or Local Complaints Committee. Right? So this was the mechanism that was to be constituted, and it was made mandatory for all the organization with more than 10 employees. But the debate started when the question of whether women should be there in the whether the political party should be included in the domain of the POSH Act started to resurface. And then some measures were given, so we'll talk about that very shortly. So before that, let's talk about the key definition. So it is essential that we understand what the POSH Act defines as sexual harassment. So it is a very progressive law which provides a very comprehensive meaning of the term sexual harassment. So all the unwelcome physical, verbal or non-verbal conduct is to be considered as sexual harassment. Includes demands for sexual favors. So for promotion or for any sort of work opportunity, if there's a demand for sexual favor, then it would be considered as an instance of sexual harassment. Any sexually colored remarks, any double meaning words which have been spoken can also be considered as under the ambit of sexual harassment. And display of pornography is also considered as an act of sexual harassment. Now, this is a very comprehensive definition of sexual harassment, because it not only takes into consideration the actual conduct, but it takes into consideration the suggestive conduct as well, right? Then when it comes to the workplace, again, the law has defined the workplace in a very inclusive manner. You can see this, that all organizations and any places that the women visit in the course of work is considered as workplace, including the extended workplaces such as the transport and the off-site location. So here it is public offices, private offices, NGOs, voluntary sector, etc. All of them are within the domain of this, including the domestic sector, the domestic workplace. Now, who will be the employees who are covered within this? So the permanent employees or the regular employees are covered. The temporary employees, such as the interns and those who are there for a short period of time, they are also covered within the ambit of the POSH Act. Then the ad hoc staff, the trainees, contract workers, and even the volunteers or the unpaid interns, right? So unpaid interns are also part of the POSH Act. Now, what is the mechanism that they have instituted? So there are two mechanisms. First is with respect to a committee, that is internal complaint committee, that we have already discussed, that organizations with more than or around 10 employees and more must set up an IC or internal complaint committee. It should be headed by a senior woman and at least 2 members from employees, and there should be an external NGO member. More than 50% of the members should be women. Now, there is local committee which is constituted at the district level in case there is less than 10 staff member or there is a complaint against the employer. So here, when there is complaint against the employer, it cannot be done under the ICC because ultimately this will be leading to conflict of interest. But here in this case, if there's a complaint against the employer or the director or the top manager himself, then it can be lodged at the local complaint committee. This includes chairwomen, local working women, 2 NGO members, and a protection member, right? Now, this is about the employment duty. What exactly is the employer duty? So, employer is supposed to provide safe work environment and display the IC order, that is the order provided by the internal complaint committee. Second, the employer is expected to conduct regular sensitization program so that all the employees are aware, not just the male employees or the female employees, but everyone is aware of their duties and responsibility. Interestingly, as per this act, a complaint has to be registered within 3 months of the act of the incident, right? So this is supposed to make sure that the act will not be misused. And the internal complaint committee is also expected to wrap up their investigation within 3 months of the date of lodging of complaint. So these are some of the procedural limitations or some of the procedures that have been provided within the ICC. Next, the employer is supposed to assist the IC or the LC during the inquiry, and they are expected to act on their recommendations. If the employer is not conducting his or her duty, it can lead to fine of up to 50,000 for non-compliance. So this is all about the background of the POSH Act and the key features. Now let us look into the need for bringing the political parties within the ambit of POSH Act. So there was a recent report by United Nations in which it stated that around 82% of the women parliamentarians in India face psychological violence, and many encounter sexual threats and demand during political activity. In fact, there was again other report that suggested that around 40% of the women have been subjected to verbal abuse, 45% of the women have been subjected to physical abuse. So the point that this report suggests that political parties are not some different kind of arena. They also provide the same kind of threats that the women face in different kind of economic activity as well. So what was the reasons that political parties are excluded? In fact, the Kerala High Court, when the petition first went to the Kerala High Court refused to bring the political parties within the ambit of the POSH Act. So what was the reason that it advanced? It said that there is no employer-employee relationship as far as the political parties are concerned, which means that the women employees are not someone who are employed by the political parties. So the employer, they are not supposed to go and enact this because they do not pay or they do not hire or pay them. So the employer-employee background part is not applicable here. The second thing is that it is not a private venture. Courts view parties as voluntary associations rather than enterprises. They are not constituted as per a particular law, right? And there is no specific legal obligation on them to provide for certain legal recourse. Third, they are decentralized and informal. They lack fixed offices and formal workplace definition. And lastly, there is risk of misuse. In fact, recently, when the Supreme Court dismissed the petition by Yogmaya, who was the petitioner, the Supreme Court said that if we include the political parties within the ambit of POSH, it is akin or it is similar to opening Pandora's box. Why? Because it will lead to several misuse of the case. And Supreme Court perhaps was talking about a case that happened in Madras where a PSU employee filed a wrong case against her employee, saying that the employer was denying her leave because she refused the sexual harassment or sexual advances against the boss. So what Supreme Court is suggesting, that the onus of this should not be lying with the judiciary. It should lie with the parliamentarians, and the parliamentarians in their all wisdom should enact a law that should explicitly bring the political parties under the domain of POSH Act. Now, the activists and the NGOs members have also advanced their own reasons. So let's take a look into some of the reasons why the political parties should be brought within the ambit of the POSH. So first thing is why it will, what is the reason for this? It would promote gender equality and participation, safe participation in politics, right? So gender equality, the problems of gender or women do not stop just because they have joined the political parties, they continue there. So in order to provide a safe environment for women at the political space, we also need this kind of provision. The second important reason is this will encourage women's entry into politics. We already know that 106th Amendment Act has been passed. And after the passing of 106th Amendment Act, several women members will be prompted or encouraged to join politics. Now, if the women join politics, it is also natural that the incidence of sexual harassment is likely to rise. So it is important that we take proactive measure instead of waiting for some heinous act to happen, then only we'll take that. So it's better that we take some action before such steps happen. Third, it protects the volunteers and unpaid members, especially who do not have any voice in the party, especially if there is any complaint against the senior leaders, that could be taken care of. Fourth, it ensures consistency with other institutions. So there are several other organizations which are voluntary in nature, which does not confine with the employer-employee relationship, but still they are subjected to the provisions of POSH. So denying the political parties with respect to the POSH Act will again be something which cannot be explained, right? So this has to be this needs to be consistent. Next, there should be independent redressal bodies to reduce the bias. Maybe they can be put within the district complaint committee, or some other committee can be formed that would ensure that they are also part of the provision against the sexual harassment. Now, what is the criticism of the exclusion? First, the literal reading undermines the spirit of the law. So more often than not, we are bound by the letter of the law, but we do not understand what is the spirit of the law. The spirit of the law is to promote and advance the women's interest, especially in workforce. So here also, we need to look at beyond the language of the law. We need to go to the spirit of the law, the actual intention of the law. Second, parties have hierarchies and power relations, which is very much similar to workplaces. So there's a senior leader, then there would be some other leaders, and then there would be some other workers, right? So there's a hierarchy in which decisions is taken, and the rest of the members are supposed to fall in line with that of the decisions taken by the senior member. So in this case, we can see that there is hierarchy present, and therefore it is very important that this hierarchy is very much similar to the other workplace. So even though there is no monetary compensation related, but still there is some sort of hierarchy associated. Therefore, they should also be brought within the ambit of POSH Act. Third, the wide definition of employee includes volunteers as well, right? Because we see that this is applicable to the self-help groups and to other organizations. So why not we also included the political parties as well? Then if you look at the existing national parties, only Communist Party of India, Marxist, has an internal complaint committee. The Indian National Congress and the Bharatiya Janata Party, they do not have any ICC, and the Aam Aadmi Party is not very clear. We are not very sure that whether AAP has any ICC or not. So as things stand, we can say that only one party has ICC, which is very unfortunate, because the political parties themselves have been saying that we need to empower women. But how can you empower women when you cannot have an internal complaint committee in your own organization? So this is something which is very much contradictory. Then the most important aspect is that the absence of sexual harassment provisions discourages women from entering politics, right? So these are some of the criticism of the decision. Now, if you want to make a conclusion, we can say that what are the way forward and what can be done in this regard? The Election Commission should advise party to establish independent grievance redressal bodies, right? So even though they do not want to constitute an ICC, that is fine, but there should be some independent grievance redressal bodies. Maybe there can be a combined body that could be formed for all the registered political parties. So this is what the Election Commission has suggested, or it should suggest. Second, then there is a legal thing that could be done where the POSH Act can be amended so that the political parties are explicitly mentioned as workplaces. So there's no scope for confusion. Third, we should create independent committees free from political influence, right? Fourth, we should conduct regular gender sensitivity and POSH awareness programs among all the workers of the political parties and those who are part of this ecosystem. Next, encourage parties to adopt code of conduct, right? So code of conduct and transparency so that everyone is on the same page when it comes to gender awareness and the safety and security of women. So these can be some of the measures that we can suggest to ensure in the meantime, right? So finally, what we can say is that the POSH Act is a result of decades of struggle. We see how there was a demand for POSH way back in 1992 when women started to enter workplace and the labor force participation rate started to increase. But still women were subjected to several problems, including wage disparity, including glass ceiling, and also with respect to different forms of sexual harassment. So POSH Act has come a long way, and to include or to ensure the women's rights, including Article 14, Article 19, Article 15, Article 21, and also in line with the international convention, right? So ensuring a safe, inclusive, and political arena is not just a legal necessity, it is a moral obligation of the society which is committed to equality. It is also, in fact, in line with the Sustainable Development Goals. So this is all from my side. Thank you and all the best.